I think that just leaves me with the pleasant task of introducing our first speaker, who is John Howard. John is Senior Vice President, Law and Corporate Affairs of Macmillan Bloedel. He has had a distinguished career both in government and in business. He obtained his Business Administration and Law degrees from UBC and Harvard, and for a number of years was an Assistant Deputy Minister and Acting Deputy Minister of Consumer and Corporate Affairs, and can be credited with or blamed for the CBCA and the new Bankruptcy Act, among other accomplishments while in government. John leapt over the wall in 1979 and since then has been with Macmillan Bloedel. He's the author and consultant of publication of many major policy studies relating to the regulation of corporations, bankruptcy, competition, and related matters, and I think an excellent choice as our keynote speaker for this morning. John? Mr. John Howard.
Thank you, Jack. I'm told that this is supposed to be relatively informal this morning. I will certainly try to keep it that way. It's a long way to come here from Vancouver, especially after just having to vote for a pay cut out there. But it's a pleasure to be here. Years ago when I was working on the CBCA, and I certainly don't want to take too much credit for it. The late Bob Dickerson, Leon Getz, Phil Annisman, and I all spent thousands of hours on that bill. Probably there are a lot of things we would still do on it had we another opportunity to review it. However, in addition to that, and one reason why I'm here today is because I will always be indebted to the local bar here, particularly the Canadian Bar subsection, which was the one effective group in Canada that cooperated with us and responded well to our requests for help when we put that bill together. That's equally true of the other bills I worked on. My presentation here today will not be so much on the specifics of corporation law. I have been asked to speak about corporation law in the 80s and to give an overview of that topic. To attempt to present in a brief paper an overview of corporate law in the 80s, which I equate with corporate law reform in the 80s, is a presumptuous, if not downright hazardous, undertaking. It's presumptuous because the topic of corporation law reform can encompass most aspects of contemporary economic life, has been the subject matter of a library of published work, and therefore lends itself to only cursory analysis in this context. It's hazardous because it can lead to the curious corporation law scholar into a labyrinth where both he and his audience can easily lose their way and never arrive at any conclusion. Although no Theseus, I shall try to lead you through this labyrinth and, if not slay any conceptual monsters, at least introduce you to the fundamental issues and the leading authorities so that you will be better able to deal with corporation law proposals in the 80s. Any discussion of law reform requires a very clear focus on the ends to be achieved and the means to be employed. This is a particularly difficult task in connection with corporation law reform because from the perspective of the policymaker, the business corporation is the most significant and most visible economic institution, and hence the ideal instrument to achieve any number of economic and social objectives. Consequently, the administrators of the corporation law are constantly under pressure to amend the law with a view to doing all things for all people. The general thesis of this paper, which is consonant with the views I stated in one of these lectures a decade ago, is that as far as possible, the corporation law should be confined as a policy instrument principally to deal with shareholder management issues and should not be recast to make corporations responsible for achieving broader social goals. Although an analog of a public sector government, and necessarily hierarchical and bureaucratic in character, a business corporation is different in three significant ways. It has one goal: to achieve profitable growth. It has one relatively crude performance measure: to earn a reasonable rate of return on the assets entrusted to it, and typically it has a relatively autocratic decision-making process which permits it to act quickly in response to dynamic market conditions. Parenthetically, I might add, to make pay cuts. To diffuse a corporation's goals and complicate its decision-making process would be to equate it with government and impose on it all the uncertainty, openness, analysis, debate, and delay that inhere in government decision-making, which would make it both slow and unsatisfying. It's slow because in the context of government, things must be seen to be done right. It's unsatisfying because the outcome is more often a compromise than an element of a rational, coherent system. That is not to say, however, that the corporation law will not be used, and used frequently, by politicians to achieve goals that are extraneous to a corporation's business purposes. Even the CBCA has been comprised to achieve nationalist and competition policy objectives that demonstrably would be better dealt with in specific laws. And recent events indicate this tendency will increase rather than decrease. Certainly the topical issue is the National Energy Program. As lawyers, we should be especially aware of this tendency, what it does to the traditional business corporation, and what changes it implies both for government and for society generally. To this end, I shall outline briefly the major political systems and their connection with corporation law, categorize the basic schools of corporate law reform, and relate them to these political systems, and then summarize the key policy issues. Finally, I will attempt to predict government-corporate relationships in the 80s. More specifically, the thesis of this paper is as follows. There are three basic political systems: capitalist, corporatist, and socialist. The trend in the liberal societies, for various reasons, is toward a corporatist system, which historically has been a compromise between capitalism and socialism. The reasons for this trend arise basically from internal conflicts that are inherent within the capitalist system. Those conflicts, as I will explain, are between the quite different goals of efficiency and equity. The conciliation mechanism that politicians tend to grasp at, and which is the political line of least resistance, is the deficit budget. The effect of that, of course, is inflation, a tax on holders of cash or liquid balances, and in effect, a transfer of payments from creditors to debtors. When inflation becomes totally insupportable, and when the traditional constraints of deflation and recession are untenable, great pressure builds up for corporatist structures. That is to substitute cooperation for competition and to permit participation in decision-making to avoid wide social conflict. Thus, I will try to argue that the future of corporate law reform will not involve the relatively easy issues of equity within the corporate structure and effectiveness of the corporation within a market context, but rather the basic philosophical trade-off between equity and efficiency. Now, any discussion of a corporatist system necessarily tends to the use of highly evocative labels such as syndicalism, social solidarity, and fascism. While it's impossible to strip these words of their pejorative connotations, to understand these concepts, it is essential to view them as part of a broad spectrum of political systems, ranging from a purely capitalist system at one pole to a purely socialist system at the other. These systems can be nicely distinguished by focusing on the two most fundamental legal institutions: ownership of property and control over dealings with property, in particular capital allocation, determination of prices and outputs, which are determined largely by contract in a capitalist economy, but by state direction in a planned economy. As used in this paper, capitalism connotes private property and freedom of contract in a market context. Corporatism connotes private ownership of property subject to state control or mixed private-state control. Syndicalism and its synonym solidarity connote public ownership and private control, in particular through private sector groups representing all social classes which cooperate to achieve common goals. And socialism connotes state ownership and state control. These conceptual models have rarely existed in a pure form, and in the real world of mixed economies are useful mainly for discussion as distinct from isolating examples. Because it's widely associated with the totalitarian governments of fascist Italy and Nazi Germany, the word corporatism has acquired an especially pejorative connotation. Originally, however, it was conceived as an alternative to a highly centralized socialist system. Instead of assuming ownership and control of the means of production, the state would unite management and labor in corporate bodies to plan investment, production, wages, prices, and profits on a cooperative basis, subject, in the event of conflict, to state arbitration. Predicated on the assumption that laissez-faire capitalism would lead to even greater concentration of industry in a few large corporations, which would be acquired or co-opted by the state in time of crisis, the corporatist concept offered a model that would preclude both labor management conflict and the development of the monolithic state, exploiting the best features of planning and private ownership. First implemented in Italy in the 1920s to consolidate and modernize industry into large, world-scale firms, it became, if not a model, at least a benchmark for the reorganization of industry and the market economies reeling under the impact of the Great Depression in the 1930s. In the United States, the National Recovery Administration, or NRA, was set up under the aegis of the National Industrial Recovery Act in 1933. It sponsored a number of corporatist groups that were empowered pursuant to NRA-approved codes to cartelize industry by dividing markets, fixing prices and wages, and impliedly determining profits available for dividends and reinvestment. By 1935, even some of the most optimistic sponsors of the NRA were attacking its cartel proclivities. It was finally struck down as unconstitutional because the excessive delegation of legislative power to the affected industries, and also because it could apply, in theory, even to purely intrastate activities. As a result, U.S. policy subsequently focused on market regulation, including antitrust regulation, as a substitute for industrial rationalization into cartel-like planning agencies. Although not implemented to the same extent, during the same period, the Canadian Parliament enacted similar laws, which were also held to be unconstitutional. Paralleling developments in the United States, the Supreme Court of Canada struck down the cornerstone laws, the Natural Products Marketing Act and the Dominion Trade and Industry Commission Act, on the grounds they were purely local in nature and encroached on provincial jurisdiction over civil rights. Although a latecomer to experiments with corporatist structures, in 1962 the Conservative government, then in power in Great Britain, set up the National Economic Development Council, the famous NEDI, as well as a number of economic development committees, which were to develop local economic plans that ultimately would be integrated into a comprehensive national plan. The original concept was an organization made up of representatives of labor and industry groups, as well as a number of qualified independent members of the public. Yielding to trade union pressure, the final membership was made up essentially of union and industry representatives. Public servants were excluded from the scheme. When a Labour government was elected in 1964, it assimilated the economic planning function into government and thus largely eclipsed the private sector planning groups. Although these corporatist models are usually associated with totalitarian forms of government, in fact, the liberal market economies have experimented widely with such models in times of crisis, where they perceived the market system had failed completely to achieve national goals of economic growth with relatively full employment. The policymakers who experiment with these systems rarely, if ever, discuss openly the conceptual nature of those systems. But in each, there is one underlying theme: the desire to achieve the sense of purpose and energy of a war economy in time of peace by canalizing the efforts of labor and industry in accordance with an overall economic plan that obviates state ownership and state direction of the planning process. In other words, the state seeks, at least in part, to substitute planning for the unseemly scramble of the marketplace, or more specifically, to substitute cooperation for competition. The apparent dilemma is that if the market economies can't adopt planning systems, they can't control inflation or unacceptably mercurial business cycles. But if they do commit themselves to planning, they must accept a much greater centralization of power, either in the state or private sector planning bureaucracies, neither of which can easily be reconciled with our traditional concepts of liberty or economic efficiency. If planning is assigned to a state agency, the process almost certainly is doomed to become enmeshed in bureaucratic red tape. If it's assigned to private sector agencies, judging from experience, they will be inclined to cartelize business in order to eliminate cutthroat competition and relax in comfortable but unstimulating and hence uninnovative mediocrity. Although they may achieve greater distributive justice or equity in the sense of distributing aggregate income more fairly among individuals, they almost certainly will engender greater inefficiency and thus cause the overall economic pie to remain static in size or even shrink. The hallmark of an economic system is the kind of incentives used to induce people to do productive work. The basic tenet of the capitalist market economy is that people are most highly motivated by the prospect of individual gain in a free market context. Although this might result in unfair distribution of aggregate income, because it is an inherently efficient system, it will cause the aggregate economic pie to grow continuously and hence will confer on each individual a larger absolute share, even if his relative share remains static. As long as economic growth in a market economy remains strong and transfer payment systems are available to absorb short-term shocks, that condition remains acceptable to most individuals. But whenever growth falters substantially, widespread disillusion sets in, and politicians, the ultimate organization men, seek new structures to deal with the problem. Since most economic activity is now carried on in market economies through large business corporations, to a large extent, the problem of fair distribution of income or social justice becomes characterized as a redetermination of the relationship between private enterprise and public power, that is, between the corporation and society. An economist, Preston, who has done a particularly incisive analysis of the issue of the corporation and society, begins his inquiry with two simple, apparently straightforward questions. What is the nature of the large corporation? What is its relationship to the economy and the larger society? He goes on to point out these questions have never entered the mainstream of modern economic analysis. That is no accident. Most economists have been so imbued with classical theory, that is, with price and the price system, as the entire field of economic inquiry, they have tended to eschew discussion or even to deny the relevance of the social matrix in which any economy is embedded, dismissing it as mere political economy. To a large degree, this issue highlights the distinction between the classical and institutional economist. As David Hamilton, a well-known institutional economist, points out, the classicist has always viewed change as discontinuous and has held that it is really a re-establishment of an equilibrium or state of quiescence. The cause of change is independent of economy. Change is caused by disturbing elements from without the system. A new adjustment must be made in response to the disturbance caused by these elements. The institutionalist, on the other hand, considers change to be a part of the economic process. Instead of viewing the economy as a fixed system periodically prodded into movement to a new point of non-motion, he holds that the economy is at all times undergoing a process of cumulative change, and that the study of economics is the study of process. But to say that the study of the relationship between the large corporation and society has not entered the mainstream of economics does not mean the issue has been ignored. Indeed, there is a superabundance of works dealing with the issue, but none that is universally satisfying, probably because the theses presented are not only controversial, but heavily slanted, at least impliedly, to reflect the political values of the writer. As a result, they either strike a sympathetic chord in the reader, or they do not. The corporation society literature, which includes works on history, political theory, organizational behavior, and management, as well as political economy, can be divided into three categories having regard to the authors and their works. These can conveniently be cast as the institutionals, the organizationals, and the philosophicals. A common thread does run through all these works. With the exception of market fundamentalists like Milton Friedman, each attempts to explain the nature of and relationship between the large corporation and the host society, free of the constraints of classical economics, but each group has a quite different perspective. The institutionals begin at the society end of the spectrum and undertake to deal with society and social processes on an aggregative or holistic basis, and in terms of major historical and institutional categories, among which the corporate sector is an important but not the single object of interest. The organizationals, as their title suggests, begin at the opposite pole, focusing on discrete corporations and groups. However, they share with the institutionalists a common historical and social science perspective. The philosophicals, in contrast to the other two groups, employ a deductive approach, positing an ideal normative model for the corporation and society, and proceeding to demonstrate why and how it should be implemented. In the relatively narrow context of prophesying the future of corporation law reform, the most interesting contrast is between one institutional, John Kenneth Galbraith, and one theoretical, Milton Friedman, whose different perspectives highlight clearly the possible different routes to corporate law reform. Galbraith's views have gradually evolved through two stages. First, that modern market society has established a new economic and social equilibrium through the countervailing power of large corporations and large unions and some other institutions. And in the second phase, that an all-encompassing institutional model, including corporations, unions, regulatory bodies, and other social entities, has developed with a view to ensuring reasonable control over defining the objectives and implementing the programs of the large corporations. Even if not altogether convincing, Galbraith's works have elicited great interest in the institutional viewpoint, including the need to understand the role of the large corporation in its broad social setting. Friedman, on the other hand, denies the need or even the desirability of examining the corporation in this broad context. He argues that the social purposes and economic impact of the corporation are determined by the function it performs in the competitive marketplace. Presumably, the consumer is the ultimate arbiter of demand and hence of social preferences. If he has information about the alternatives, will by the act of consuming express those preferences. Hence, the conclusion of Friedman that the social responsibility of business is to increase its profits. While the most attractive prescription to the practical manager, in an era when virtually all business is highly regulated, it has to be taken more as a statement of the normative goal than as a result based on any experience. Indeed, as Daniel Bell reminds us, that prescription is predicated on the doubtful assumption that the marketplace does perform the function Friedman attributes to it. Bell argues that the theoretical virtue of the market is that it coordinates human interdependence in some optimal fashion, in accordance with the express preferences of buyers and sellers. But what ultimately provides direction for the economy, as Veblen pointed out long ago, is not the price system, but the value system of the culture in which the economy is embedded. The price system is only a mechanism for the relative allocation of goods and services within the framework of the kinds of demand generated. Accordingly, economic guidance can only be as efficacious as the cultural value system which shapes it. Although, like Friedman, a philosophical, Bell departs in precisely the opposite direction. Friedman's tacit predicate is the utilitarian theory to the effect that individual choices in the marketplace express individual preferences, which in aggregate express the greatest good for the greatest number, or, in other words, the utilitarian theory of value. In contrast, Bell argues that the free enterprise market economy and its lead institution, the business corporation, has played not only a leading but also an unquestionably legitimate role in our society because its values, which are to economize and maximize the output of material goods and services, are consonant with the values of most individuals in the host society. For a number of reasons, the legitimacy of that single-minded role are being brought into question. Population growth brings continuously greater pressure on scarce resources. Goods other than economic goods, such as wilderness areas, pure water, and clean air, are becoming more scarce and assuming increased importance. Consequently, individuals are less tolerant of economic externalities or spillovers, such as economic or environmental pollution. I might add also legal pollution to that. In spite of the emphasis on individual material gain, most individuals and even firms tend to look to the state for more compensation to enable them to adjust to major unforeseen economic shocks. In a vast economy that is so complex, individual and even large firms feel trapped in a web from which they can't extricate themselves by their own efforts. As a result, there's an increasing centripetal flow of power to the state to make the most important economic and social decisions. It is this trend that Daniel Bell characterizes as the shift from an economizing to a socializing mode. From a society where basic social decisions are simply the consequence of the aggregate decisions of individuals and firms in the marketplace, to a society where those decisions are made increasingly on the basis of the decision makers' political values. In brief, there appears to be a secular shift, again to quote Bell, from governance by political economy to governance by political philosophy, which is a turn to non-capitalist modes of social thought. Thus, any discussion about corporate law reform necessarily drives the policy analyst, if he seeks to encompass more than shareholder-management relations, into a far broader policy arena. In that broader context, he must consider not only structural adjustments to the corporate form, but the nature and social purpose of the corporation itself. For example, assume the issue is a suggestion to place employee and public interest representatives on the corporate board. What actuates such a recommendation? Is it merely a means to improve communications? Presumably that could be better achieved by other means without diffusing the business goals of the corporation. On the other hand, is it consciously a means to give decision-making power to workers and outsiders and thus to compel the corporation to seek broader social goals? What are those goals? Even if cast narrowly, as better working conditions, better products for the consumer, a better environment, or more generous contribution to parks and symphony orchestras, in the final analysis, such goals are predicated on the assumption that the corporation, its shareholders, and perhaps its employees are receiving a disproportionate share of the economic pie, and therefore that the corporation should become involved in income redistribution. In a sense, the corporation thus becomes a surrogate for the state, but without the state's powers to raise revenues, create money, and implement comprehensive programs and redistribute wealth and income. Indeed, it is this very issue that leads us to the root problem. The capitalist state encourages free enterprise and the resultant differentials of income and wealth accumulations to foster the efficient production of goods and services. To even out somewhat these differentials in the name of social justice or equity, the political decision makers introduce progressive income taxes and transfer programs in addition to defense and other traditional programs. But these decision makers find it politically difficult, if not impossible, to raise enough taxes to pay for these programs. Therefore, they either borrow heavily and drive up interest rates or simply monetize the debt. Either way, they generate inflation. This trend then leads to further consideration of extraneous controls on political decision making. For example, constitutional requirements to balance government budgets, statutory limits on the growth of the money supply, a return to the gold standard, complete autonomy of the central bank to control money supply, a public interest commission outside government with constitutional power to place a ceiling on government expenditure budgets, and finally corporatist structures to substitute planning or cooperation for the market environment. Thus, at the root of all these issues is the trade-off between efficiency and equity, or more bluntly, on the one hand, the capitalist market tempered by redistribution and regulatory programs, and on the other hand, a state-directed economy. Liberal society has sought through redistribution and regulation to resolve the inequalities that inhere in the market system, but for political reasons, apparently is unable to do so without engendering unacceptably high levels of inflation. Although inflation may at first seem somewhat remote from the subject of corporation law reform, in fact it underlies many reform proposals, but usually only as a tacit premise. To understand this relationship requires a short digression on the causes and effects of inflation. The simplistic explanation of the causes of inflation is the quantity of money theory, to the effect that in any time period, inflation will occur if the total supply of money created exceeds the total of goods and services produced in that period. In such circumstances, households, corporations, and governments are able to bid up the price for those goods and services and hence force up the general price level. But that explanation is unexceptionable in general terms. But if that is the root cause, the solution is self-evident. Exercise central bank powers to constrain or reduce the money supply to the point where it equals the total of goods and services produced, and the problem of inflation will simply disappear. Unfortunately, however, there are a number of subsidiary causes, or more precisely, chronic conditions underlying the money supply issue that make it an especially intractable problem. The analysis of the subsidiary causes or conditions can conveniently be categorized as the perspective of the generalists on one hand and of the structuralists on the other. The generalists focus on fiscal policy, which encompasses both revenue and expenditure policy. They point out the apparent impossibility of reconciling the policy objectives and the political imperatives of freely elected governments, which of course is to be re-elected, and the obvious need to control the money supply. Almost without exception, as a matter of policy, governments seek to maximize economic growth with nearly full employment and reasonably fair distribution of wealth and income. But governments, like corporations and households, tend to be big spenders when the economy is buoyant and hence fail to reserve resources to stimulate the economy during a recession. Indeed, they tend in a recession to cut back on even desirable spending programs and so aggravate the downturn. Thus, inherent in the mechanisms employed to stabilize the money supply in market economies are a policy bias in favor of stimulative fiscal policy, a political bias against less spending and against higher taxes to support that spending, and a social bias toward implementing long-run open-ended income transfer programs that involve fixed costs, reduce the amount of discretion governments have to administer the economy, and so further reinforce an inflationary propensity. From the generalists' perspective, it is the collision between free enterprise tenets and the ethical imperatives of an egalitarian democratic society that engender inflation. Governments, in spite of substantial experience, persist in pursuing, concurrently, very costly defense, full employment, and transfer payment programs without increasing taxes to pay for these programs. The only way to achieve these ends are to borrow heavily and maintain a high rate of growth in the money supply and accept the consequential inflation. The only other alternative is to tighten the money supply, reduce liquidity, force up interest rates, engender a recession, and in effect abandon the basic social goal of virtually full employment. A particularly perceptive economist, Summers of the Conference Board, argues as follows: the bureaucratic instincts that lead to such deficits are essentially conciliatory. The rise in social spending accommodates the egalitarian ethic, while the shortfall in revenues avoids the still higher progressivity of the tax structure that would be required to balance the budget and thereby restrains and defers the impact on private incentives. In effect, the budget deficit helps to keep social peace at the troubled border between democracy and capitalism. In the same way, the rapid creation of money finances social spending and suppresses the financial consequences in the private sector. In modern societies, fiscal and monetary policies may be enabling conditions of inflation, but they do not cause inflation, and they cannot stop inflation. In fact, it is truer now to say that inflation causes budget deficits and rapid money growth than to put it the other conventional way. All three phenomena, inflation, budget deficits, and rapid money growth, are coordinate reflections of the ethical invasion of free markets. In these circumstances, virtually every Western economy, and for somewhat different reasons, all developed economies, have resorted to incomes policies intended to slow the destruction of liquidity by inflation. Incomes policies and their usual resort to numerical calculation of fair prices, wages, and profits are an ethical response to an ethically induced inflation. They invoke the public interest against private market determination, particularly where, as in the case of wages, ethically oriented institutional changes have left a heavy deposit of inflationary market power. In short, the generalist view is that the political bias inherent in fiscal policies creates the underlying conditions that compel a tendency toward an excess money supply and hence inflation. Thus, although the immediate cause is excess money supply, the feasible political solution is not simply to constrain the money supply. There is no simple symmetry between the cause and the cure. The real cure requires dealing with the underlying conditions, which in turn implies a transformation of the values of individuals to enable them to accept the sacrifice required to reconcile reasonable economic growth and equitable transfer payments. Again, to quote Summers, it is not too much to hope that democratic systems, grown more aware of the challenge they face, recognizing the dangers in asking more of man than he is yet able to deliver, and confronted with the evidence that predominantly socialized non-market economies have their own desperate problems will settle into a long-term compromise, at least as to rate of change. What we might hope for is an institutional structure that will preserve a vigorous competitive arena at the same time that it accommodates technology and seeks social justice. A structure that will provide a suitable home for the complex, partly competitive, partly cooperative, enormously diverse animal that is man. The generalist perspective is frequently labeled demand-pull inflation. In contrast, the structuralist argument is that large corporations have become so powerful they can determine prices, and that large industrial unions have become so powerful they can compel an employer to meet their wage demands. The employer corporations, because of their size and market power, are able to increase their prices and so pass on these costs to the consumer. Assuming there is no external constraint such as international competition, neither is concerned because each has sufficient monopoly power to preserve its relative market position. At one time, these transfers would have led to a transfer of income from non-union employees, particularly white-collar employees in both the public and private sector, to union employees. Now, however, consonant with a generally accepted equality ethic, and in part the desire to avoid unionization, employers quickly increase other employees' wages to maintain the relative share of each group. As a result, wages and salaries tend to rise quickly right across the board. The usual proposals to resolve this issue are of two kinds. The short-run proposals advocate an incomes policy, a generic euphemism for various techniques of wage and price control, in particular wage controls, to constrain income increases and bring aggregate demand back into balance with the eligible or available supply of goods and services. The longer-run proposals advocate the use of competition laws to break up business corporations and unions into smaller units and so eliminate their market power and thus achieve that same balance. Although undoubtedly a factor in maintaining inflation once fiscal policy has initiated the process, it appears unlikely the structural factors have any substantial causal effect. During the period 1945 to 1960, the same industrial structure existed in North America, but inflation was easily contained. It was not until the United States attempted, without raising taxes, to finance concurrently the Vietnam War and the Great Society programs that inflation took off. And because of the key function of the US dollar as an international currency, that inflation was quickly spread around the world. Once initiated, the structural factors simply reinforced that inflationary trend. Assuming the root cause of inflation is the demand pull engendered by expansionary fiscal policy, if we can transform the values of the consumer society to induce individuals to produce more, demand less immediate satisfaction of perceived needs, and share income more equitably, democratic states can introduce a political process that constrains the inflationary bias in market economies, applying conventional Keynesian techniques to maintain an acceptably stable price level and, at the same time, an acceptable level of unemployment. The issues are elegantly summarized by Ezra Solomon. If the monetary or demand pull factors provide the dominant explanation for inflation, two things follow. The laws of supply and demand are still working, and serious inflation can be prevented or corrected through traditional policy measures which work by preventing or curbing aggregate demand. If, on the other hand, the structural factors provide the dominant explanation, it would suggest that in the future, reasonably full employment and reasonable price stability cannot be simultaneously achieved within a free market economy. According to the structural view, modern inflation arises not because the laws of economics are working, but rather because they are not. In short, it implies that direct intervention or control over wage and price decisions must eventually become a permanent feature in market economies. Assuming demand-pull inflation is the root issue, if the market economies cannot transform individual values and apply traditional macroeconomic policies to contain inflation, they must face frequent recessions as the economic whip to bring supply and demand back into balance. They must also face, as a corollary, the possibility of serious social conflict. The only other means to resolve the problem are essentially non-democratic. That is, to set up bureaucratic controls over fiscal policy to constrain the powers of legislators to make decisions in respect of the revenue and expenditure budgets. If cost pull inflation is the issue, a market economy cannot function effectively, and the legislatures must substitute overall planning, or, in other words, substitute bureaucratic directives for the interactive bidding of autonomous actors in the marketplace. Not comforted by either of these alternatives, advocates of corporation law reform have suggested other techniques that aim, at least in part, at reconciling the conflicts between, on the one hand, the market economy incentives of disproportionate income and wealth, and, on the other hand, the democratic requirement of reasonable equality. Hence, the search for corporatist solutions. These are the basic issues that must be kept in mind when considering corporation law reform in the 80s. In Canada, as recently as 1972, one could largely ignore non-market institutions as alternatives to the traditional business corporation designed to function autonomously in the marketplace. These would be subject only to the competition laws and other regulatory constraints. The other alternatives were well known, but could be relegated to the background as ideas that were not only foreign, but completely unorthodox. Since then, Canada has experienced two major recessions, experimented with comprehensive wage and price controls, introduced increasingly nationalistic laws that tend to insulate Canadian firms from foreign competition, increased substantially the already extraordinary number of crown corporations used in Canada to achieve conventional business objectives, enlarged both direct and indirect subsidy programs, and even nationalized, in part, the energy sector. In sum, although Canada has long had a mixed economy in the sense of having a mixture of private and public business firms, it seems to have accelerated considerably the shift from market or economic control to political control over business activities during the last decade. As a result, one is compelled to expand the scope of the phrase schools of corporation law reform to encompass non-market institutions, including both corporatist and socialist institutions. I had hoped to be able to express this graphically, but I'll just sum up these schools of corporate law reform very briefly. Looking at the two poles, that is the market institution at one pole, that's a traditional business corporation, where the emphasis today is on disclosure and on accountability. At the other pole, we have the non-market institutions, the planning systems, effected either through nationalization or wage and price controls. In between these two poles, we have the corporatist institutions. These can be characterized as a social audit, employee share purchase plans, or more commonly, board structuring techniques. These various board restructuring techniques include appointing government officers to the boards of private sector companies, the use of various constituent directors representing suppliers, consumers, labor, and others, or the most common of all, the so-called co-determination model of appointing labor directors to the board. In the context of the traditional market economy, the CBCA model of the business corporation, although it undoubtedly can be improved, meets the basic requirements of corporate democracy, disclosure, and accountability, in particular the accountability of directors, officers, and majority shareholders for any unfair exercise of their power, or, in a general sense, for any breach of fiduciary duty. Since the CBCA became law in 1975, the emphasis on corporation law reform with respect to large corporations has been on corporate governance, a phrase that subsumes two trends. The first is increased emphasis on accounting disclosure, not only on the quality of disclosure, through refinement of accounting standards, but also on understanding better the inherent limitations of accounting information. The second trend emphasizes the accountability of management, which is commonly characterized as corporate governance. Sponsored in large part by the bureaucrats who administer the corporation and securities laws, not surprisingly, they suggest more corporate bureaucracy to confine more narrowly the broad discretion exercised by corporate directors and officers. That is not to say, however, that the bureaucrats' recommendations do not make sense. Most do, and assuming outside directors are not manipulated by corporate management, they can be effective instruments. In addition to accountability to creditors and shareholders through the courts, these proposals introduce administrative techniques that limit the powers of directors and officers to make self-serving decisions and, above all, to bury any skeletons in the corporate closet. Specifically, they involve using a majority of outside directors on board nominating committees, executive compensation committees, and above all, audit committees. Some go further to suggest that corporate resources be made available to outside directors so that they can retain independent advisors when they are not satisfied with internal sources of information. All these proposals aim at rendering corporate directors and officers accountable on a continual basis to outside directors who have no vested interest in the corporation and who in turn are accountable to the corporation's creditors and shareholders. While cumbersome, it is difficult to refute the arguments supporting implementation of these administrative techniques, which have become almost commonplace in large corporations. The non-market institutions are largely self-explanatory. By far the most important illustration in Canada is the direct intervention of the state in the oil and gas industry through Petrocan, and its indirect intervention through the tax laws and through the National Energy Program. The obvious tendency of all these initiatives is to acquire greater control over the Canadian economy, and particularly Canadian industry, to reduce the amount of capital available to private sector firms, and to increase the power of public servants to allocate capital to long-term mega projects. While such strategy does make possible long-term planning, it also concentrates capital for allocation in very large amounts and hence increases enormously the danger of a wrong decision. In sum, for the messiness of the market, which imposes the burden of relatively small losses on management, creditors, and shareholders of the firm that made the investment error, these policies substitute a plan which shifts the burden away from such decision makers to the public generally, diffusing responsibility very broadly and to a large extent relegating accountability to the general electoral process. But in any event, these policies have little relation to corporation law reform. The corporatist institutions, although they may have a pervasive effect, are frequently introduced to deal with seemingly specific problems and therefore are much more difficult to assess. For example, superficially, the idea of a social audit seems unexceptionable. Who can deny the desirability of compelling a corporation to disclose that it is a good corporate citizen in the sense that it takes steps to minimize environmental pollution, minimize exposure of employees to dangerous working conditions, eliminate racial or sexual discrimination in the workplace, assure consumers are sold safe, reliable goods, and support local cultural aspirations? Although one way to deal with these issues is through corporate disclosure, a better way is, as far as possible, to set out standards in specific laws and enforce those standards, either through the courts or through regulatory tribunals. That places the responsibility for setting standards where it belongs, in the legislature, and focuses responsibility on the corporation and its directors and officers. Even more important, it avoids diffusing corporate objectives away from the single objective of running a profitable business, an objective that lends itself to at least crude performance measurement and hence makes feasible management accountability. Such general issues as charitable contributions or support for local cultural groups can easily be accommodated within this context if they are characterized as costs incurred to improve community relations or employee performance. Employee share purchase plans are also, on the surface, attractive institutions to reduce labor management conflicts and to motivate employees to increase productivity. For relatively small firms, they offer obvious advantages. In large firms, however, employees tend to be merely passive shareholders. For employees generally, owning shares has the advantage of increasing the sense of participation directly in the corporation's business, but it is unlikely to reduce labor management conflict with unionized employees whose principal source of income derives from wages. And it almost certainly will increase the exposure of employees to greater risk of loss. If the corporation's business and profitability declines substantially, in addition to the possibility of losing his job, the employee faces losing a substantial part of his savings because of the almost certainly depressed market price for the corporation's shares. Thus, by far the most interesting and controversial corporatist schemes involve restructuring the corporate board of directors to include government-appointed directors, directors of various constituency groups, such as suppliers and consumers, or simply directors representing employees. Although they cannot simply be discounted as harmful or ineffective, The first two techniques have the clear disadvantage, like the social audit concept, of diffusing responsibility and hence reducing the accountability of management to creditors and shareholders. The third alternative, the use of employee directors, has elicited far more interest and experimentation, and therefore merits closer attention. Although usually associated with attempts of the Allied occupation governments to restore industry in Germany immediately after the Second World War, in fact, the German institution of co-determination stems from the 1919-1920 revolutionary period, when councils of workers and soldiers were established in Kiel, communist revolts occurred in major cities, and a Soviet republic was actually established briefly in Bavaria. It was a conscious effort to return to pre-capitalist forms of business enterprise that would serve as a substitute for more radical state-owned institutions. First enacted as law in 1920 in Germany, the idea languished in the 20s, was suspended during the Nazi period, revived informally by the occupation forces in 1946, and finally reintroduced formally by a law enacted in 1951 to deal with the coal and steel industry in Germany. In a culture where rural workers were never thrown off the land by enclosure laws, as in Great Britain, but rather were attracted to urban centers because of the obvious advantage of having a job in industry, this was not a surprising development. Labor was never treated as a commodity, and hence terms of employment were not generally determined by collective agreements achieved by adverse party bargaining at the local plant level as we know it. Although unions and collective agreements did develop, the origins and the relationships were totally different. To a large extent, the unions derived from socialist political parties. As a result, the collective agreements frequently were national in scope, negotiated between national associations of employers and employees, and applicable to an entire sector of an economy on a countrywide basis. This structure left a serious gap, both at the specific plant level and the overall firm level, where there was no formal employer-employee relationship or mechanism to deal with local conditions and local grievances. To fill this institutional gap, Germany and other European states that had adopted the German model enacted statutes creating works councils at the plant level and requiring the appointment of labor directors at the firm level. Given the history and culture of continental Europe, this seems a logical, if not inevitable, development to bridge the institutional gap between liberal and socialist political parties, and as a corollary, to achieve reasonable labor management harmony. Because it appears to have worked reasonably well in Europe to avoid sharp confrontations that characterize labor relations in North America, the co-determination model has elicited extraordinary interest. Legal scholars who have studied the issue in depth generally remain skeptical that such a culture-specific institution can be transplanted in the North American environment, where collective bargaining was consciously developed under regulatory statutes as a pure market device to equalize bargaining power between big unions and big industries. Indeed, until very recently, corporations in North America forcefully resisted any labor intrusion into the corporation's business, whether indirectly through access to non-public corporate information concerning production and forecast profits, or directly through representation on the board of directors. In specific or special situations, some North American corporations have agreed to expand the scope of collective bargaining to encompass subjects such as plant removals, plant closures, automation, and major capital investments. But generally, they tend to resist any constraints on management decision-making. The unions, consistent with their conceptual origins, have also generally resisted proposals to place union representatives in corporate boards, fearing the union might be co-opted to the corporation's goals and so undermine its own reason for existence in a market economy. Recently, however, business exigencies have compelled a few large corporations to agree either to open their accounts or accept labor directors, or both. Chrysler is the current example. In each such case, the corporation was in financial difficulty and made such concessions with a view to forcing the union involved to look at the corporation's competitive position and to negotiate realistically with a view to reducing production costs, either by reducing wage rates, eliminating work rules, or both. Given the North American adverse party bargaining culture and the size and power of the unions, it's difficult to imagine any substantial change of present attitudes and institutions. But given also the severe pressure being placed on North American firms by foreign competitors, a fundamental institutional change may be the only way to change worker attitudes, eliminate costly work rules, and so increase productivity. The present experiments at least test the institutional alternatives. In any event, it is clear that co-determination achieved by appointing labor directors is not a simple means to resolve labor management conflicts. It implies a fundamental transformation of values of labor law and of corporation law. In Bell's terms, a transformation from governance by political economy, which is determined largely by the marketplace, to governance by political philosophy, which will be determined largely by those who share power in the decision-making process. Now, just to summarize, I'll repeat again what I have tried to point out is that there is no simple way to look at the problem of corporation law in the 80s. In 1972, when we were working on the CBCA, the federal law was so far out of date, it was a relatively easy task to try to improve shareholder management relationships, to assure equity within the firm itself, and to make the corporation work better. In addition, we simplified enormously the formalities of dealing with the corporations, both in the corporate offices, law offices, and in the government offices. In the 1980s, there is no doubt there will be great pressure to develop some kind of fundamental corporatist institution. Even at the risk of being characterized as a fundamentalist, which I'm certainly not, I urge now, as I urged in 1972, that all of us be very, very conscious of these background issues and that we resist corporatist structures as far as possible in order to make sure that the business corporation is able to continue to work as an effective instrument to carry on business. Thank you very much.
John, thank you. I'm afraid we gave you a particularly large topic to deal with in an unduly limited period of time. I want to thank you for a particularly thoughtful opening address. I think it does give us a framework for the more particular matters we're going to be dealing with over the next 3 days. And specifically to thank you for traveling from far off Vancouver to be with us. So thanks again.